Welcome everyone in the Zoom audience. I'm Terry Magedy, the chair of the elder law section of the trust and estate section of the Beverly Hills Bar. And the first thing we do for our program is hear from our sponsors, because we owe them all a debt of gratitude for their support of our programs. So, and we'll start with our longtime sponsor, Nancy Sanborn, and the Sanborn team.
The Sanborn team has been privileged to serve our real estate clients for over 40 years.
We represent residential as well as commercial assets.
We serve clients in Southern California and collaborate with agents throughout the United States.
Our clients come first, and our focus is on obtaining results.
From attorneys to fiduciaries and administrators, we have systems in place to make sure your clients' needs are met.
When you hire the Sanborn team, you are joining thousands of satisfied clients.
Your continued support has made the Sanborn team the #1 choice in trust and probate real estate. Thank you.
Thank you, Sanborn team. And now our sponsor, Ori Gadish, who will introduce herself and tell us about her company.
Thank you, Terry. Hi, everyone. I'm Orit Gadish with Geffen Real Estate. We specialize in both commercial and residential real estate sales. Over the past 15 years as the broker, I've developed best practices that serve my clients' best interest in the probate and trust space. Most importantly, as a real estate broker, I bear the fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with my clients, similar to the duties that a doctor and a lawyer have to their patients and clients. If we haven't spoken yet, please feel free to reach out to me so we can schedule a Zoom call and get to know each other. Back to you, Terry.
Thank you, Orit. And now I want to also thank our third sponsor, Marcine Klein from Glen Oaks Escrow, just a top-notch escrow company who specializes in the areas we deal with: probate, elder law, and as we speak, I'm seeing Marcine in action on one of my deals. So she does a tremendous job. So thank you, Marcine, for being our sponsor. And our fourth sponsor I'd like to thank is California Title Company. California Title Company, also a title company that, like the other sponsors, specialize in our area: probate, trusts, elder law. And I really want to thank them too for being our sponsor and helping us out with all of our programs. And a few housekeeping matters before we start. Actually, before the housekeeping, I want to just mention our next program, which is March 24th. And we're going to have our very own Andrea Kushner speak, who's been a long-time active member of our bar association, talking about prudent investor rules and trust for people with disabilities. So, and older people, the niche that we focus on. So I'm looking forward to that on March 24th. And now for the housekeeping rules. First, the questions for our program can be posed in the question and answer little box at the bottom of the rectangle on your screen, not the chat. And then Dmitry will address them, or plan to address them if there's time at the end of the program. I'm told by our bar that you should get your MCLE certificate right out to you in about 24 hours, right after the program ends. And somewhat of an unusual announcement, which I don't think I recall making before, but there are some pictures that some people may consider like graphic because it's about, we're talking about physical abuse of people. So if that sort of thing is hard for you to see, then, avert your eyes if you can, but that's just a warning. And now I want to turn the program over to Dmitriy Cherepinskiy. I can't say enough good things about Dmitriy. He's just known Dmitriy a long time, top-notch litigator in this elder abuse space, which, as everyone knows, that's my space. But when it comes to suing facilities for elder abuse and neglect, skilled nursing facilities, assisted living facilities who've done wrong by people who are there, then Dmitriy is just top notch, and he has a unique part of his background, which is at one time in his career, or earlier, he worked for the other side for, I believe, Dmitriy can clarify, but probably insurance companies who were defending facilities. And then he came over from the dark side to the light side. And I could just tell you, anybody knows from a professional perspective, when you've been on one side of the battle and then now change and go to the other side of the battle to fight these places as a plaintiff, you have a unique perspective that really tremendously contributes to your effectiveness in litigation. So with that, I'll turn the program over to Dmitriy for abuse in skilled nursing facilities, assisted living facilities, particularly in the age of COVID. The materials, I believe, are also, they were emailed to you, but they're also now, I believe, in the chat box if you want to look at them there. And now for the next about 55 minutes, the program's all yours, Dmitriy.
Thank you so much, Terry, for this very kind introduction. I appreciate it. The rumors about my competency are greatly exaggerated, but I will try to live up to your introduction in today's talk. I am coming from the background of a former professional malpractice and elder abuse defense, and that gives me a perspective into the way these facilities operate and the way they are defended. As I like to say, if I spent years building tanks, I know the weak spots in their armor, so to speak. I know the weak spots in terms of how these facilities are defended and where they are vulnerable in terms of litigation and the care they provide or elect thereof. So that's what we'll talk about today. The subject matter of today's talk is elder abuse and neglect, especially in the era of COVID-19. So without further ado, the first slide that we're going to be talking about is the difference between the different types of elder care facilities. And there are two main types of facilities. One is skilled nursing facilities, also called nursing homes. And the other one is residential care facilities. We're going to be talking about the ones for the elderly, although there are residential care facilities for adults. They are for people who have developmental disabilities and other types of disabilities, but are not elderly yet in terms of their age. But today we're going to be talking about the residential care facilities for the elderly, also known as assisted living facilities. So what are the differences between the two? The skilled nursing facilities operate for the care of those residents who have acute care needs. For example, they are bedridden, they cannot ambulate or walk on their own. They need regular medications. They need regular physical therapy, occupational therapy. They need medical supervision and care on a 24-hour basis. The residential care facilities provide housing essentially and some assistance with daily living for those who do not have acute care needs. These are typically people who may have some memory problems. Maybe they have a mild dementia, so they need assistance with their bills or financial aspects of their life. They may need assistance with bathing, feeding, and other activities of daily living, but they do not have such severe health issues that would require them to be at a higher level of care facility, such as a nursing home. So this is pretty much the difference between the two. The assisted living facility is a non-medical setting, and the nursing home or skilled nursing facility is a medical setting. Another way to differentiate the two is to state that the skilled nursing facilities are an institutional setting, and assisted living facilities are a residential setting. What else is different between these two? Staff. The staff at skilled nursing facilities are licensed nursing staff, which goes from the registered nurses down to licensed vocational nurses and to certified nurse assistants or CNAs. The staff at assisted living facilities are unlicensed caregivers, and there is essentially only one nurse at the facility who holds an RN degree, and that's typically a medical care or a care director. Another main difference between these two is that an assisted living facility is not a healthcare provider, and a skilled nursing facility is a healthcare provider. And finally, what makes these facilities different is that the intended length of stay. At skilled nursing facilities, residents are planned to stay there for a short time, although there are some residents who spend years at nursing facilities. Typically, these are residents who are bedridden, non-ambulatory, those who are, have suffered a stroke or some other debilitating injury or condition, and as a result, there is no expected improvement in their status in the long term, and they stay at nursing homes for a long time, essentially until the end of their life. However, the main intent for these facilities and the main type of a resident that they house are people who are there for a rehabilitation purpose, such as a short rehabilitation and physical therapy program after a hip replacement surgery or after a mild stroke or another condition that is expected to improve. And at the residential care facilities for the elderly, the length of stay is indefinite. It's a home away from home. It's a new home for these elderly residents, where the main difference is the ability to get help from caregivers who can assist with bathing and feeding and other daily needs. So again, what are the types of care provided at the skilled nursing facilities versus residential care facilities? Skilled nursing facilities, as I indicated before, provide acute care needs and services for those needs, such as post-surgical rehabilitation, post-hospitalization rehabilitation, physical therapy, occupational therapy. They provide IV medications and respiratory assistance for those people who, for example, need to be on a ventilator type assistance. And the types of assistance provided at residential care facilities or assisted living facilities are different. They're non-acute, they're largely non-medical, and they are things such as social support, for example, assistance with activities with other peers at the facility, playing games, bingo, and other games, assistance with mobility, ambulation, transfers in and out of bed and chairs, assistance with eating, dressing, bathing, and toilet needs. There are also special wings at assisted living facilities which are devoted to residents who have mental health issues such as dementia and depression and other mental health issues. And they are intended to provide these residents with assistance with those types of issues. And finally, assisted living facilities provide assistance with management of medications and finances. And in terms of medications, again, this is not the type of care provided at a skilled nursing facilities. This is essentially somebody coming in and helping an elderly resident take their medicine, telling them, did you forget to take your medicines for today? Let's do this right now. This type of an assistance. What are some inherent difficulties related to providing care to elderly people, regardless of the type of the facility they're in? Mental issues. The most common is dementia. Dementia, unfortunately, affects a very large percentage of elderly population, and it leads to severe difficulties such as lack of memory, lack of cooperation. Sometimes residents with dementia can be aggressive, and in some cases they can wander away from the facility. And if a certain facility does not have checks and balances in place, including competent guards and gates, locks, etc. Obviously, it's not a prison, but nevertheless, there have to be certain measures taken to prevent residents who have dementia and severe cases of dementia from wandering away. And jumping on to the physical limitations, some of the most common difficulties involve mobility, especially in nursing home setting. People who are bedridden, they are very vulnerable to getting the most common type of an injury for bedridden patients. And we'll talk about it. We're talking about the bed sores, also called pressure ulcers or decubitus ulcers. If a resident is bedridden or immobile, then they can definitely suffer those types of injuries, such as bed sores, if they're not turned and repositioned every 2 hours. Another type of difficulty is transfers. I'm talking about transfers in and out of bed, in and out of a chair. They need assistance, otherwise they can fall. And balance. A lot of times, elderly residents, regardless of whether they are in a nursing home or an assisted living facility, for one reason or another, have difficulties with balance and they need assistance with walking and transfers again. Otherwise, they can fall, and falls are extremely dangerous for elderly people because they can suffer either a hip fracture, which frequently, unfortunately, ends up being fatal, or they can hit their head and suffer a fatal or debilitating brain hemorrhage. And facilities, regardless of whether they are a nursing home or skilled nursing facility or an assisted living facility, they have to deal with some internal pressures, and they face a dilemma involving two aspects: quality of care and sufficient and qualified staff. Oftentimes, it is an inverse relationship between these two factors. The higher the quality of care that a facility aims to provide requires a more competent staff, requires a sufficient level of staff, and that means it's a lower profit margin. If a facility or its management wants to increase its profit margins, what do? They have to make compromises in terms of the quality of care and the staffing. This is the type of a balancing act that is done by assisted living facilities and nursing homes daily. And where does neglect occur? It occurs in those cases where the profit margin wins, where it outweighs the efforts to provide sufficient quality of care, and the facilities and their management choose their financial bottom line over the needs of their residents. That's where we see understaffing and neglect come up. So what do? If they want to put their profits over the needs of their residents, they start cutting corners. Facilities and their management frequently engage in understaffing. They know that by California regulations, there needs to be a certain number of nursing hours provided to a resident, and they violate those requirements by deliberately understaffing their facilities, by making just a few people care for a large number of residents. I have personally been told by several nurses who quit their jobs at certain facilities because they just could not handle it any longer. They were so overworked that they felt they could not provide quality of care. There were only two nurses assigned to over 50 residents at a nursing home, and it happens with more frequency than we could imagine. What else do? Facilities use registries. There are staffing registries that provide nursing staff and caregiving staff on a need basis when, for example, somebody calls in sick or is on a certain leave of absence or otherwise is unavailable. Then facilities such as nursing homes and assisted living facilities can engage the assistance of a registry. Registry staff does not have the same type of a commitment to a facility and its residents for one simple reason. They are frequently there for a day and then they go off to another facility. So what type of accountability do they have? What type of an incentive do they have to provide quality care to residents if they may never see them again? Unfortunately, it's an inherent problem in dealing with registries and the staff they provide, because they have no incentive to provide a sufficient quality of care. There is frequently a failure to screen short-term staff from registries. These nurses and assistants provided by staffing agencies and registries are frequently not qualified, don't have sufficient experience or education, and nevertheless, they do get to provide service to elderly residents, which ends up being insufficient and incompetent. Again, facilities frequently hire unqualified staff because they can pay them less. And finally, what they do is they fail to purchase safety equipment, such as, for example, floor mats and bed alarms. These devices are extremely important in making sure residents do not fall, for example. Somebody who is a fall risk needs to be in a special type of a bed, and there needs to be a floor mat with bed alarms so that when they attempt to get out of bed or they're falling out of bed, the staff is alerted to that. Frequently, it's not done. In March of 2020, we learned that the facilities did not have enough PPEs, or personal protective equipment, such as masks, gloves, gowns, etc., and that led to the outbreaks of COVID-19, and it raged at several nursing homes throughout the state and throughout the country as a wildfire. And where do the staff members cut corners? Essentially, that's done through incompetence, indifference, overloading, and frustration with low pay and stress. The staff essentially is overworked, underpaid, frequently incompetent, and as a result, the quality of care that's provided to residents suffers tremendously. So in March of 2019, the facilities throughout the country went on a lockdown, and the era of COVID-19 came marching in. How did it affect the problems that had already existed at nursing homes and assisted living facilities? There were multiple issues that flowed from the COVID-19 pandemic. We learned that the facilities, as I indicated before, were not prepared. They did not have a sufficient number of personal protective equipment, such as gloves, gowns, masks, shields, etc. It resulted in more severe understaffing, because all of a sudden, facility staff members, such as nursing staff and other staff, started getting exposed and sick with COVID-19. They were placed on sick leaves, they were placed on quarantines, and they did not come to work. Did the facilities seek replacement? Sometimes they did, sometimes they didn't. Again, it resulted in severe understaffing at nursing homes as a result of so many staff members being out either sick with COVID-19 or quarantined because they were exposed to COVID-19. A lot of times, the staff members were simply afraid to go to work. They would call in sick or come up with some other excuses just because the nursing homes and assisted living facilities were had so many staff members and residents who had COVID-19 that employees were petrified to go in. Another problem that flowed from the COVID-19 pandemic was the ineffective methods of dealing with exposure. It resulted with extensive quarantines of residents. Residents would be placed in separate COVID-19 wings of facilities where they would be just left. I heard from nurses that they would be afraid to go into those COVID-19 wards. And can you imagine what was happening to those residents? Let's say somebody is bedridden and cannot walk, needs to be turned and repositioned every 2 hours, and they have been exposed to COVID-19. They're placed in this COVID ward along with a bunch of other people who have been exposed to COVID-19, and nurses are afraid to walk in, and they're understaffed, and they don't have enough number of nurses. So what happens? Nobody walks in, and nobody turns and repositions these residents, and they end up with bed sores appearing or getting worse. Another impact of COVID-19 was the lack of oversight. Until March of 2020 and the time when the facilities went on lockdown, families were able to go in, visit their loved ones. They would see what's going on. They would see bed sores. They would see that their loved ones are not feeling well. They would ask them, what's going on? Have you been getting help? However, all of a sudden, starting in March of 2020, all facilities throughout the country went on a lockdown. All visitations were prohibited, and it's still the case. It's been almost a year, and visitation is still prohibited. What does it mean? It means there is a lack of oversight from the families, and it's important. In my opinion, families play a crucial role in the oversight of long-term care institutions because they frequently enforce the provision of good care to their loved ones. However, if they can't see what's going on, if they don't know what's going on, that just means there's more of an opportunity to neglect residents. This is the unfortunate effect of the COVID-19 era on the problems existing in nursing homes and assisted living facilities. So what is the actual law that applies to elder abuse and neglect cases? It's the statute that is codified in California Welfare and Institutions Code 15600 at SEC, and it's called the Elder Abuse and Dependent Adult Civil Protection Act, or EADACPA. The physical abuse, the abuse of an elder or dependent adult is defined as physical abuse, neglect, or other treatment with resulting physical harm or pain or mental suffering. How is elder abuse different from medical malpractice or negligence? The most important difference is that the type of wrongdoing involved in elder abuse and neglect has to exceed mere negligence. If somebody is an elderly person and they're fall victim to some negligent conduct, doesn't mean that negligence coupled with old age automatically means elder abuse and neglect. Case law states, and one of the most important and seminal cases in elder abuse and neglect arena is the Delaney versus Baker case. It's a famous case that was decided by the California Supreme Court in 1999, and it largely defined certain aspects of this until then murky, new, and largely unknown statute. So what the court in Delaney versus Baker said was that there can be no claim for abuse of a dependent adult unless a plaintiff can demonstrate by clear and convincing evidence that the defendant is guilty of something more than negligence. And the acts prescribed by the Elder Abuse Act do not include acts of simple professional negligence, but refer to forms of abuse or negligence performed with a state of culpability greater than mere negligence. So it's a form of a claim that is inherently more difficult to establish than mere negligence. What are the differences between physical abuse and neglect? Physical abuse means assault or battery, for example, when there is an actual physical conduct or a use of a physical or chemical restraint for any purpose not authorized by the physician or surgeon. Assault and battery occurs rather infrequently. In my career, I have encountered it only a few times, and it could be either in the context of one resident who, for example, has dementia and is aggressive, and that resident hits another resident, but this is more of a negligent supervision type of a case. The pure type of assault and battery in the context of physical abuse is when a nurse or a caregiver is aggressive, and when faced with a resident who has dementia, for example, and is uncooperative, instead of calmly trying to redirect that resident, the nurse would actually physically hit, restrain, or push, or somehow physically submit or subdue that residence into compliance. These are rather rare occurrences. Chemical restraints and physical restraints, they occur more frequently. Physical restraints could be, for example, something like a bed rail in a hospital bed. Somebody is kept in a hospital bed with the bed rails up at all times, and as a result, they cannot get off the bed. Or residents who have dementia and can sometimes be disruptive to the routine of the staff. They are subdued with the use of very strong psychotherapeutic medications such as Haldol, Risperdal, and others, which essentially chemically restrain them and turn them, unfortunately, into these slouching, drooling people who are just sitting in their chairs all day long because they have been chemically restrained with psychoactive medications. It's really horrible when that happens. Neglect, on the other hand, involves the failure to assist in personal hygiene or in the provision of food, clothing, or shelter, or the failure to protect from health and safety hazards, or failure to prevent malnutrition or dehydration. These are the types of neglect. Let's talk about some examples. Well, the first one, obviously, COVID-19. Is this a type of neglect? Well, arguably, it is. Is a wrongful death claim involving COVID-19, when somebody dies as a result of COVID-19, is it a viable claim? Theoretically, yes, it can be a viable claim. What are some of the practical difficulties? On the one hand, you can prove or attempt to prove that there were violations on the part of a nursing home or assisted living facility in terms of following guidelines by the Center for Disease Control, Medicare, and for example, California Department of Health, in following infectious disease protocols, in purchasing the necessary numbers of personal protective equipment or PPEs, etc. Theoretically, it can be proven. What are some of the practical difficulties? The insurance companies have taken the statewide, and I can probably say the countrywide approach to defend these cases with no cost spared. Why are they instructing insurance defense firms to be extremely aggressive in defending COVID-19 cases? Well, the answer is easy. Just the number of people who died of COVID-19 at nursing homes in 2020 is so tremendous that if there is compensation paid to every victim, then the insurance companies will simply go out of business, because there is no amount of insurance funds that would be sufficient to compensate all those victims. So it is an existential issue for both nursing homes and insurance companies. Insurance companies are doing it because even though theoretically they have the financial means to cover those claims, they don't want to pay millions and millions of dollars in those claims. And there are also coverage issues. I have heard that a lot of insurance companies are writing reservation of rights letters to nursing homes and assisted living facilities where they explicitly say, we are not going to cover any claims for injuries or death arising out of COVID-19. They just don't want to cover those claims. There are some legal challenges. There are a few cases pending right now in California involving COVID-19, and the defense is taking aggressive steps to defend these claims. What they do is they try to remove them to federal court and argue the federal officer doctrine. For example, they argue that since they had to comply with the regulations by Medicare and CMS, as well as the Center for Disease Controls, which are federal agencies or quasi-federal agencies, therefore these facilities were a federal officer, and therefore the claim should be removed to federal court. They also argue that they are qualified for an immunity and preemption of a federal question under the PrEP Act. Are these successful arguments? So far, some cases have been remanded back to the state court, and some cases are still pending in federal court. It is largely unpredictable. What's certain is that these are not easy cases by any means. Physical abuse is another example. For example, if it results in a wrongful death, when a nurse hits somebody and the resident falls and hits their head and dies. Again, it's rare, but it can happen. Bruising. Physical abuse can result in bruising. Physical abuse can result in fractures because the bodies of elderly residents are extremely fragile. And any impact, especially if they fall, can result in a fracture. And some fractures can be fatal, especially hip fractures. It's a known fact that for somebody who is elderly, a hip fracture can unfortunately be fatal. And a lot of residents do not survive hip fractures. Physical restraints are a type of a physical abuse, as I discussed, placing somebody who has difficulties with ambulating and mobility and who cannot get out of bed unassisted, placing them in hospital beds with bed rails is a type of a physical restraint that can unfortunately lead to very, very dramatic and horrible consequences. Chemical restraints are a type of a physical abuse. And as I discussed, giving psychotherapeutic drugs such as Haldol and other drugs to residents with dementia is a type of a chemical restraint or an artificial method of subduing them. Neglect. Again, neglect can result in wrongful death when, as a result of neglect, the resident suffers a fatal injury. One of the most common examples of neglect are Decubitus ulcers, which are also called pressure sores or bed sores. And they occur if residents who are immobile and they need to be turned and repositioned every 2 hours are not turned and repositioned every 2 hours. And it inevitably leads to the development of pressure ulcers, which are, once they develop, they are extremely difficult to treat. It takes months and months and sometimes years for those sores to heal. They have to heal from inside out. If you can imagine a book that is open and it needs to close from the inside out. This is how these sores have to heal. Sometimes they require a surgical debridement. For example, if it's an unstageable sore which is covered with eschar, or essentially a scab on the outside, and it's unclear what type of a sore it is, it needs to be surgically debrided, and then you can discover the full extent of that bed sore or pressure ulcer, whether or not it exceeds, whether or not it goes down to the fat or sometimes down to the very bone. So these are probably some of the most horrible types of injuries that result from neglect in the setting of long-term care. Dehydration, malnutrition, and weight loss are also some of the examples of neglect. The poor or lack of personal hygiene that could lead to rashes, skin issues, or sometimes outbreaks of scabies at nursing homes, which can lead to very traumatic and sometimes even fatal outcomes. Infections. We're talking about MRSA or methicillin-resistant Staph aureus infections, scabies, and obviously COVID-19, right? So infections can be very severe and can sometimes be fatal. For example, if somebody has a pressure ulcer that is further neglected and bacteria enters that open wound, it can lead to sepsis, where the bacteria gets into a person's bloodstream and it results in septic shock and frequently can be fatal unless it's treated in a hospital setting timely. Lack of supervision and safety precautions results in falls, wandering and getting lost or injured, sexual assaults by other patients and residents, fights with other patients and residents, and neglect of signs and symptoms of serious diseases. I have seen cases where a resident would fall and have a fracture, but the staff at a skilled nursing facility would fail to recognize that the person may potentially have a fracture. They would fail to get a timely x-ray. Months would go by and the resident would decline, and the fracture would lead to an infection, sepsis, and in some cases it was fatal. What are some of the specific written rules that can be used in these cases, or can qualify as a sort of a violation per se of the law? Title 22 of the California Code of Regulations, it governs assisted living facilities, and California Code of Regulations also governs nursing homes as well. Policies and procedures. A lot of times, long-term care institutions have specific policies and procedures in place that are intended to ensure quality of care, and these facilities violate their own policies and procedures. The Patients and Bill of Rights. These are documents that are codified in the Health and Care Code, and these documents are placed in the charts for residents, and a lot of times facilities violate their own documents and the Bills of Rights for residents. So what are some of the advantages and challenges of the elder abuse claims? What are some of the theoretical advantages? Typically, in California law, we all know that in personal injury cases, when the plaintiff dies, their pain and suffering dies with them. The elder abuse statute creates an exception to that. It resurrects the pre-death pain and suffering of the victim, but limits it to $250,000. So this is an advantage. You can get the pre-death pain and suffering. Also, in cases where elder abuse is proven, the plaintiff can recover attorney's fees. Although to do that, the wrongdoing has to be proven with clear and convincing evidence, and you have to prove recklessness, oppression, fraud, or malice, and satisfy the typical punitive damages requirement of the Civil Code, Section 3294. And again, punitive damages can be recovered in successfully prosecuted cases of elder abuse and neglect. So what are some of the practical challenges? The pleading standard. The elder abuse and neglect cases have to be proven with particularity. They have to be alleged with particularity. For example, the negligence cases are subject to just notice pleading. You don't have to allege any specific details. But from the get-go, when asserting an elder abuse case, you have to allege specific and particular facts. Otherwise, it will fall victim to a successful demur. The burden of proof. Again, in regular personal injury cases and medical malpractice cases, the burden of proof is the preponderance of the evidence, where all you have to do is just slightly tip the scale and prove that the wrongdoing is just more likely than not the cause of the injury or death. In elder abuse and neglect cases, the burden of proof is clear and convincing evidence, which is a much higher level and much tougher burden of proof than the preponderance of the evidence. So essentially, to prevail, you have to prove by clear and convincing evidence that a defendant is liable for physical abuse or neglect, and that the defendant has been guilty of recklessness, oppression, fraud, or malice. These are very, very tough requirements, which are much more difficult to establish in reality than in a regular negligence case. What are some of the practical challenges? The elder abuse cases are aggressively defended by insurance carriers and their counsel. Why? Because of the additional exposure to potential pre-death pain and suffering damages, attorney's fees, and punitive damages. Especially now, as I indicated before, COVID-19 cases are defended even more aggressively than the regular elder abuse and neglect cases. These cases require extensive discovery, and they're much more expensive to prosecute as a result. Cases take longer to litigate in the elder abuse arena, and especially now. What is the impact of COVID-19 on all cases, not just elder abuse and neglect cases, is court closures and trial continuances. As I'm sure you know, trials are continued to 2022 and 2023, and it is unclear when the pre-COVID trials are going to resume with regular juries and a lack of restrictions. So in this context, it's not just elder abuse and neglect cases, but all cases have been significantly affected by COVID-19 and the practical challenges faced by our courts. So this is it. I hope you found some of this interesting and useful, and I will now open it up for questions. So let me see what questions. Are care requirements different between a private versus non-private skilled nursing facility? Is it true that during the COVID-19 lockdown, they have been granted leniency by the overseeing agency with respect to staffing and resident care? Is this leniency still in place? Well, there is no such thing as non-private skilled nursing facility. All nursing facilities are private in the United States. There are some potentially public facilities that provide skilled nursing care, such as the Veterans Administration facilities, and public facilities such as, for example, public hospitals that have long-term care wings, but they're very, very rare. The requirements are the same, except those who are government entities may potentially have a federal immunity if they are federal agencies. Is it true that the COVID-19 lockdown resulted in a leniency? Well, at this point, this would be probably speculative, although the California Department of Health has recognized some of the difficulties and challenges faced by nursing homes. And again, I have no proof of this, but I have heard rumors and speculation that the enforcement of the alleged violations has not been as aggressive as some people would like. And the reasons for that would be that the Department of Health understands the difficulties faced by nursing homes in light of this pandemic. What about the Wynn versus Pioneer case and the care custodian requirement? Well, the Wynn versus Pioneer case stands for the proposition that to be liable for elder neglect, the defendant has to be a care custodian. And a care custodian means somebody who is entrusted with care and custody of a resident. Essentially, this means that it is going to be very difficult if not impossible, to sue a physician, a doctor, for elder abuse and neglect, because doctors are not care custodians. They are healthcare providers. So the impact of this case means that the primary defendants in such cases are long-term care institutions and not physicians providing care at those institutions. Let me see. What liability is there is the ratio that is allowed by law. It's not enough because of the needs of dementia. Okay. Well, I'm going to try to answer this question. Hopefully, I've already answered it. The liability, there is no specific ratio, no specific number. The only number that's specific is the pre-death pain and suffering, which is limited to $250,000. The rest of the damages, if proven at trial, are subject to the jury's discretion. Whatever they decide in terms of the punitive damages, that's the number that they're going to award. And if the resident is not deceased but live, then the damages are not subject to $250,000 limitation. I think this is it for the presentation. And Terry, back to you.
I just want to thank you so much, Dmitry. I mean, what a thoughtful, detailed presentation. I mean, it was excellent. I mean, excellent quality materials, excellent, addressing of all the issues. So we really appreciate it, Dmitry.
Thank you.
We learned a lot. I learned a lot. So thanks a lot. And goodbye to everyone in the Zoom audience. We'll plan to see you for our next program.